Hi, Ms. Lisa. This is my speech for the rights of criminal defendants. Okay. Good evening, cadets. My name is Chief Sollman, and this evening I am here because Chief Lisa was transported overseas for an investigation, and she asked me to fill in for her. I would like to start off by discussing why these 4 specific amendments are important for you to know, and as we get started, first off, I would like to ask if anyone knows or has ever heard of the rights of criminal defendants. No? Okay, well, let's get started. What are the rights of criminal defendants? When a person is charged with a crime, they become a criminal defendant. The government must prove guilt beyond a reasonable doubt before convicting and punishing a defendant for a crime. The United States Constitution provides criminal defendants with many constitutional rights. These rights control how the government investigates, prosecutes, and punishes criminal behavior. These include rights provided in the 4th, 5th, 6th, and 8th Amendments. 4th Amendment rights. The 4th Amendment provides protection against unreasonable searches and seizures. The United States Constitution requires probable cause for searches and seizures. The rationale is that the government may not use illegally obtained evidence against you in court, although warrants are needed for a search or seizure. There are exceptions to the rule. And I'd like to give an example based on a former colleague of mine. At 6:08 a.m. on October 4th, 2009, Tricia Oliver frantically called 911 from her apartment in Cranston, Rhode Island, when her 6-year-old son, Marco Neves, stopped breathing. The fire department took Marco to the Hasbro Children's Hospital, where he was found to be in full cardiac arrest. He died 11 hours later. By 6:20 a.m., Sergeant Michael Kite, my colleague of the Cranston Police Department, had arrived at the apartment where he found Oliver, her boyfriend Michael Patino, and their 14-month-old daughter, Jason Oliver. Kite observed a couple of stripped bed linens on the floor, trash cans with vomit on the inside of it, dark brown vomit in the toilet, and crucially, a cell phone on the kitchen counter. Kite picked up the cell phone, and it was at that point, in the just-released opinion of the Rhode Island State Court, that the police proceeded to mangle a murder case and violate Patino's 4th Amendment rights by viewing the text message without a warrant. Kite viewed the text message on the phone, which was owned by Tricia Oliver, reading, "What if I have to take him to the hospital? What do I say?" And those marks on his neck, OMG. The message was sent from Oliver to Patino. Although the sending of the message apparently failed, there were other messages on the phone with profane language and references to punching Marco 3 times, the hardest of which in the stomach. According to court records, Patino was arrested and charged with murder. Kite claims he picked up the phone because it was beeping, and that he thought it might help get in touch with the boy's birth father. But yesterday, Rhode Island Superior Court Associate Justice Judith Savage threw out nearly all of the evidence police collected from that point on, including the contents from the cell phone records, communications provided by Verizon, T-Mobile, Sprint, Nextel landlines, and even Patino's confession for the death of Marco Neves. Savage said that almost all the evidence obtained by the police was tainted by illegal searches made by Sergeant Kite or other illegal searches and seizures of the cell phones and their contents. Patino is fighting the case on both constitutional grounds and on the facts. He says injuries to the boy were an accident and result of horsing around. Now, a privacy question that remains unsettled. Savage's decision in the state of Rhode Island versus Michael Patino is a bold but interesting one. Because the status of the text message and the criminal investigations remain unsettled in the United States, Savage wrote this: "This court finds that it is objectively reasonable for people to expect contents of their electronic text message to remain private, especially in this day in law enforcement." Patino had the right of privacy for his text message conversations, whether police took them from his phone or Oliver's, and a right to privacy in an apartment because he frequently stayed there, making it one of his residences. Based on a large amount of illegal evidence collected by the Cranston Police Department, this court grants defendants suppression motions and excludes the state's core evidence from being used at trial, including the text messages, all cell phone contents, all cell phone records, critical portions of the defendant's videotape statement, and his written statement given to the police. Savage wrote, "In addition, this court finds the defendant made a preliminary showing that in numerous sworn statements made by police officers and a dozen warrant affidavits were either deliberately false or made in reckless disregard of the truth as to entitle him to a Franks hearing, subject to further argument on additional preliminary issues. The cell phone searches were illegal as warrantless or in excess of the warrants obtained, and as such of these searches and seizures therefore were unreasonable in violation of the Fourth Amendment, the judge wrote. Savage reasoned that the cell phone contents are deserving of Fourth Amendment protection against unreasonable searches and seizures because the people generally keep them on their persons at all times. Text messages are often raw, unvarnished, and immediate, revealing the most intimate of thoughts and emotions of those who are expected to guard them from publication. She wrote, further stating that the court does not find the remote possibility that the unintended party will receive a text message due to his or her possession of another person's cell phone is sufficient to destroy an objective explanation of privacy in such message. But Savage's decision is unlikely to be the final word on this topic. Savage herself noted the U.S. Supreme Court has declined to provide guidance to lower courts. Even the United States Supreme Court has struggled with legal challenges raised by emerging technology, most especially in the realm of cell phones and their contents. She wrote, indeed, in the city of Ontario versus One, the parties asked the High Court to decide whether text messages should be afforded Fourth Amendment privacy protection, but the Supreme Court declined, choosing instead to decide a case on narrower grounds and allow this question to percolate in lower courts. An Associated Press story on the Patino case noted that Georgia's Supreme Court this year ruled a similar search was legal, but the Ohio Supreme Court ruled that such searches improper. The Patino trial was scheduled to begin Monday, but Savage canceled jury selection. The AP reported Patino's lawyer, David Cooper, said that he'll request for bail for Patino, who has been in prison for almost 3 years. Savage's decision was also reported by the Providence Journal, which posted the entire 190-page ruling online. Most Rhode Island departments do seek warrants before gathering text messages as evidence, Cooper reportedly said. Why Cranston opted not is beyond me. Cranston police ended up obtaining more than a dozen warrants to seize evidence, including cell phones owned by both Oliver and Patino, but the affidavit used to obtain the first search warrant contained no information about text message or cell phones, even though Sergeant Michael Gates claimed police seized phones from the apartment based on the authority of the first warrant. This was inaccurate both because the warrant did not grant authority and because the police actually seized Patino's phone off his person at the station. So that sums up our Fourth Amendment rights, and now we'll move on to the Fifth Amendment. The Fifth Amendment protects against self-incrimination, the right to remain silent, and double jeopardy. The right to remain silent. Criminal defendants have the right to remain silent. This protects the defendant from self-incrimination, commonly known as Miranda rights. During arrest at a trial, criminal defendants also have the right to confront accusers and to testify on their own behalf. The right against double jeopardy. The United States Constitution prohibits the government from retrying a defendant for the same crime. This is called double jeopardy. Besides criminal charges, a criminal defendant can also face civil claims. And now on to Sixth Amendment rights. The Sixth Amendment provides criminal defendants with the right to legal representation, the right to a speedy trial, and the right to confront witnesses. The right to representation. Every criminal defendant has the right to adequate legal representation. If the defendant cannot afford a lawyer, the government will provide one. Keep in mind, adequate representation does not mean a right to perfect legal counsel. It does protect the defendant from serious legal blunders made by his lawyer. The criminal defendant also has the right to decline legal representation and represent himself. The right to a speedy trial. Criminal defendants have the right to a speedy public trial. This ensures the government will not conduct secret hearings that might violate your individual rights. On occasion, however, a court will close a hearing to protect the identity of the victim, which is usually, in most cases, a minor. The right to a public jury trial. A criminal defendant also has the right to be tried by a jury. The form of the jury varies from state to state. all juries consist of members of the community randomly called by the court, selected by the lawyers for the prosecution and the defense. Additionally, criminal defendants have the right to a speedy trial. This protects defendants from sitting in jail for long periods of time before their guilt has been established. The right to confront witnesses. The Sixth Amendment gives the accused the right to cross-examine or confront witnesses. This gives the defendant the ability to counter any testimony presented against him. This also helps the jury determine whether the witnesses are reliable. Additionally, this right allows the defendant to face the witness in person. Only in rare cases may the witness avoid obligation of having to confront the defendant. Now on to the final Eighth Amendment rights. The Eighth Amendment provides criminal defendants the right to reasonable bail and the right to not be subjected to cruel and unusual punishment. The right to a reasonable bail. Criminal defendants may leave the holding cell if bail is given to ensure the defendant's return for the trial. If the court does, the bail must not be excessive with regards to the severity of the crime and the person's likelihood of fleeing. The right to not be subjected to cruel and unusual punishment. The Eighth Amendment prohibits cruel and unusual punishment if the defendant is convicted. This right guarantees prisoners access to the basic medical treatment. It also guarantees that sentences are not disproportionate to their crime. For example, someone convicted of petty theft should not receive a sentence of life imprisonment without parole or death. So an ongoing question that goes on is, should I get an attorney if I'm charged of a crime? And the answer is simple: of course you should. Legal representation can be crucial if you are charged with a crime. Criminal charges are life-changing, and it is in your best interest to get counsel. An experienced defense attorney can help protect your rights and represent you in court. Well, class, I hope you enjoyed my version of Miss Lisa's speech, and I hope you learned something in today's lesson on criminal defendants. And I hope I didn't bore you too much. Thank you.